You are listening to Lone Star Community Radio on 104.5 KCZWLP Conroe and 106.1 KZCCLP Conroe and worldwide on irlonestar.com.
Good afternoon and welcome to The Legal Connection with Toni and Cheryl. Toni Lynn Collins and Cheryl Ellsworth Jahani here. We are both two Texas licensed attorneys, and we are here every Tuesday from 12 to 1 p.m. On The Legal Connection, Lone Star Community Radio. You can listen to us live on 104.5 or 106.1, or you can watch us live on Facebook. And you can message us, too, with your questions if you have questions. So, Toni and I are here today talking about appeals.
Yes, and we haven't been live on the air for a while, and there's just so many things that have been going on that are just, that need to be addressed. And one thing I want to bring up that, it's kind of in the news right now is two things. Two things I want to bring up. One is the Kurds and the Turks. And I know that's not a political, and if you're not really watching TV and you're raising your family, you're not really watching that all the time. But that's kind of a big deal.
Right.
I mean, the Kurds were helping us get rid of ISIS, and now we're pulling all of our troops out suddenly. And then the Turks, who are a NATO ally, but they haven't really been like the friendliest group. And of course, my husband's Greek, and the Turks and the Greeks had, they were kind of at war for a while. And so my impression of the Turks is not as good as it would be had I not known a little bit more history about them. Okay. Mm-hmm. That being said, I was sort of stunned that President Trump suddenly pulled all of the troops out, not for the wrong reasons. I think it was important that we take care of our own border and we take care of ourselves, but that it was so sudden. It seemed like they were our friends, and it'd be like if somebody was helping you and then like you were helping them with the case, and then
in
suddenly,
the middle of a trial,
and then
they
you said,
just
"I gotta go. You're every man for himself. This is pro bono. I'm not going to do this anymore. I've got somebody else that needs more help. I'm going to take care of myself." That would be stunning if you weren't easing into it, almost kind of like a diet, a starvation diet versus kind of a low boil. So I'm hoping that maybe it was just a thing for the media, that he wasn't showing his hand and that he's really not pulling everybody out at once, that he's kind of doing it more slowly because these people would be in
dire
straits and grave danger because they weren't prepared. That's all in life. You need to be prepared, like everything. Like when people go to church, they're preparing for the afterlife, I guess, if you want to look at it like that. But anyway, so that was the first thing, and I was talking to my husband Jim, who is just so highly intelligent about all this, and he reads all those. We always watch The Longest Day and Patent, and we went to Normandy, and we know all about the Joan of Arc, and we look at all the history of the wars and Battleship and all that kind of thing, and he had a pretty good solution for it. It was. We do need to pull out. We do need to not be in the Middle East forever representing other countries, but we need to have them like you do it in court, like you tell your clients. You need to mediate.
Is my notice.
You need to mediate and settle, and there shall be a penalty if you don't comply with that. So there should be. Jim's solution is yes, we should pull out of the Middle East, but. With a certain, maybe not broadcasting that deadline, but they should have a deadline where they're going to have to meet. And I think Jim said it should be right away. I thought it should be a little bit more of a slow boil, because at the same time our servicemen are being killed for another country. But at the same time,
just so you guys know, I just wanted to see if this was the first time President Trump was talking about it. There was talk of it December 19th of 2018.
When?
December 19th.
There was a New York Times, New York Times political article talking about he plans to pull troops from Turkey or from Syria, Turkey.
So
they did have.
Was he just talking about it though, or was he?
It said he plans to pull troops out. Did
Yeah,
he
it
give a date?
said. They said he planned to pull 2,000. Oh man, well now of course they need a subscriber thing.
You're right. He's been talking about it for a while.
I'm just letting you know. I'm just when y'all talk about, hey, we just randomly pulled, a
But
left turn on Tuesday. It's like
Well,
I think they've been talking about
talking
it, so.
about it and then doing it and literally really doing it, like, calling for impeachment or something.
It depends on how specific he was
Right.
when he talked
Yeah, it's
about it.
another article from the Washington Post. U.S. troops to be pulled out of Syria quickly, White House says. And that was on December 19, 2018.
Oh, wow. Okay. Well, Jim's solution, to get to what I was really going to say, I thought a solution was pretty good, was we need to get everybody out and tell them that you better work out an agreement, some kind of mediation, some kind of settlement, because this is not our war. This is your war. And if one or the other doesn't comply with it, like give them a little stretch of land that's like almost like the Gaza Strip, even though that's pretty bad too. But it made sense to me, and I'm not like a big on the war and all that stuff. I didn't go to, the Citadel. I know nothing about it, but it seemed logical because you can apply it to the law where you've got two factions, and the United States is like the attorney or like the judge, and we're trying to sort of step in there and make things better when it's really not our problem, just like an attorney. A lot of times it's just not our problem, but we're in there to try to make things better. And if you held them accountable to a settlement that they entered, and then there were sanctions, serious sanctions for somebody that breached that sound like that should be the way it always is. But then again, I haven't got a lot of military training. That's just me kind of talking out loud. But I was really disturbed by the Kurd thing. But I'm glad you brought that to our attention.
Yeah, me too.
That if it has
Because
been
I think
about
everyone's
2
saying
years.
that. Maybe nobody noticed that in December
Yeah.
of last year, and now he's actually doing it,
Yeah.
and everybody's saying, oh, what a shock.
Yeah, I don't think that. I think it's because it was almost like somebody in one of our divorce situations. I'm going to get a divorce. I want a divorce. I want a divorce. And then somebody finally files. It's like, well, we weren't going to divorce. We were just talking about it. That's what happens to a lot of my clients. They just think it's they're not calling their bluff, and then they really are serious. They want it. So anyway,
Right.
that was the first thing. And the second thing was, there was two things that came up. One was the Kurds. Oh, I can't remember. It'll come back to me. But I will bring up that we recently got to meet with Sean Spicer.
Yeah.
That was so much fun. Sean Spicer came to town to promote his book, and he talked
Called
to
the briefing.
a briefing. I called the briefing, and he talked to children in several schools, the John Cooper School and various other ones, about how we got into the position that he got in, and Dancing with the Stars, and when he first found out about when he first saw Melissa McCarty, doing the spoof on him in Saturday Night Live, just. What a wonderful person. It was such an
was
enjoyable
great.
meeting that we got to meet him, and also Land Commissioner George Bush. Two wonderful people, and I was just
So true.
You have to kind of watch that to see when they're in town, and more people should do that. It was just a fun place.
How did you find out about that meeting?
This is really weird. I was doing a jail visit with one of my clients, and I didn't even know I could get reception in the jail with my phone. And I just got a phone call from the land commissioner's assistant saying, hey, we're going to be in the Woodlands. Do you want to come to a breakfast? And I thought it was going to be like a Trump rally. I thought it was going to be massive. And
Yeah, I did too.
and so I got there, pretty much right on time. I didn't get there early or late because I'm not really that much of an early morning person, as you know. And we got there, and it was just a small group, and we got to really talk with them. And these are really nice people that really want to
Very
make a
nice.
difference. And the land commissioner was all about bringing the rich history of the Alamo and really getting the real story out, and how we should really look back on what they did for us and really appreciate what these people did, these heroes that fought for our country so we can have the freedom that we have right now. And so they're doing some really good things. And
That's awesome.
I am really not just their advocate now. Next time they come around, even not so much, I will be there supporting them and bringing more people into their to support them just for how nice they were. Genuinely nice people from the heart.
Very, very nice. We even got a picture of you dancing with Sean
Yeah,
Spicer.
I asked him, I'm like, can I get a picture with
was
Dancing with
so
the Stars?
cute.
And I don't know how to dance at all. It's just insane. And he literally said, okay, no problem, fine. So I have a picture of me dancing with,
Sean
and my
Spicer.
aunt said, he can really dance. And he said, no, you could tell by my scores. And I'm like, no, you're still in. He goes, no, the people. And he said
That's
something that
right.
was really interesting. He said he was really, it really kind of, the backlash and the negativity, if that's a word, the negative sort of feedback he'd get from the press about, and he was just doing his job, really did hurt his feelings. You
Right.
can be strong.
You
but
asked him that question.
hearing
you said,
that
you're
all
so
the
nice. How do
time,
you, right.
even if you don't believe
That was a
it.
great answer.
He said that that when he got the votes for Dancing with the Stars that kept him on, that really sort of uplifted him. And you wouldn't think that somebody of that stature that has been, in the Navy and supporting his country for so long, and
military for 20 years,
and doing everything he can to be a patriot would that would be something that would be important to him. But everybody's got a heart. There's always a purpose for our life, and we don't always know what it is. You just have to listen to God and go forward. Which reminds me, Altuve. Did you read in the paper? He's a hero right now. He got the home run that put us in the World Series.
that
basically.
little short guy.
And
so amazing.
There was an article in the paper saying that everything was for God. He said that his faith is more important than any of that, and I was just like
Good for
taken
him.
back by that. Okay, so we're talking about appeals today.
Yes, we are. We're talking about appeals. An appeal is a process where cases are reviewed from lower courts. They're appealed up to higher courts called appellate courts. And just to ensure that the proceedings went correctly, that there was no abuse of discretion.
An error, yes.
Looking for error.
Did the trial court, regardless, that's the first place you're going, is in court. Now, of course, you can't appeal if you settle. It's going to be really difficult because you've made an agreement. That's not error if you've made an agreement. You're held to your signature in the agreement that you made.
Unless there was something wrong with that agreement, like coercion, duress, something like that.
That's really
But
hard to prove that. So you, and of course, as we talked about in previous shows, you can record, if you're not an attorney, you can record a conversation, so you can record a mediation, you can record a meeting at your homeowners association, but not if you're an attorney, but you have a right to do that, and it's admissible in court if, as long as you were there and you can actually prove it up yourself. And so that's sort of your proof if you are in a mediation, or a lot of times you can't bring your phone in, like in the JP court over here at the Montgomery County Court 3, they will not allow any recording devices or a court reporter. And I don't know if that's changed, but we had a trial there, and I wanted a court reporter because if there's error, you want to be able to bring it up. But in JP court, there is no error because you have de novo at the county court as your appeal. So if you just wanted to, if you thought you got a bad rap over if you had a trial over in JP court for whatever it may be, an eviction, or I think the one that we did was for public intoxication. It seems silly, but it really is important to people when they get arrested properly for that. I wanted to get a court reporter, and the judge wouldn't let us bring any recording devices in.
That is interesting.
So because she didn't want to be, it was when Judge Connolly was in. I think she just didn't want people to hear if she made a bad decision, which is what happens on appeals. But if you go to court and you have a jury or a bench trial, the next level up is you're looking for error.
It's error, and the other thing is interpreting law.
Yes.
Yeah, so interpreting or fleshing out.
An error in the law or an error in fact. You can have, I've written a gazillion briefs, but you can have an error of fact or an error of law. And both of them.
Which means that the lower court misapplied the law.
Yeah,
right?
factual insufficiency and legal insufficiency. The lower court, perhaps, and this happened to me in the federal courts too. I had a case that I won $500,000 verdict against constable in a
where
jury
was this?
trial.
This was in the federal
In
court?
federal court, yes. And we won. It was a long, drawn-out trial, and they had, I'd come into this with another attorney, and they, the opposing side, which was the government, had filed a summary judgment, and they lost, right? It was denied. So we went to trial, and we won a $500,000 verdict against a Harris County constable for harassment against all of his deputies, these women deputies. This is about 20 years ago. And they appealed the judgment that the judge, I don't think she's on the bench anymore. It was Judge Harmon. She, like 6 months after that, we were waiting for the judgment to come out. We were so excited, me and my co-counsel. And the judge rendered a judgment notwithstanding the verdict, and she said there was an error of law, that there was a governmental immunity. And we thought we could get around it because there was this little known law about constables, that you could sue constables in Dallas County, but you couldn't because of the way the system worked in Harris. But of course, we thought we could, and so that was overturned, and we ended up in the Fifth Circuit with that. But that was an error of law. Now, let's say that we had a jury trial, and we properly preserved error by objecting and asking for the whatever said to be stricken. For whatever reason, we were able to secure that error, so to preserve that error. Then that's going to be a factual error. So that's factual insufficiency, and that's when you can go to court and get a reversal on either a legal insufficiency or a factual insufficiency, and sometimes both. And sometimes it's a gray area, and it can be both. And I remember I got one a bench trial overturned on a legal insufficiency because they flat out did not apply the law. The court just didn't. They had a really good. The opposing side had a trial counsel that was really good friends with the judge, and we could not win in this court to save our lives, and so we appealed it, and we won on appeal because we got it out of the court. We got the bias out of it, and so I guess what we're
When you went on appeal, it's just remanded to the same court, right?
well, it can be reversed and rendered or reversed and remanded.
So what happened? Did they render?
This one was not reversed and rendered because there was a factual issue with regard to the amount of damages that had to be determined. But it got reversed and remanded because the decision was improper because they didn't follow the law. The contract in this particular case said you had to do certain things, and that was not done. It was clear error. I mean, we just rolled our eyes. It was like, I can't believe we just lost on this ruling. It was so clear. So we only had one point of error in the brief, and I wrote it literally in like 8 hours while I was on my way to Greece in the airport, which is not something anyone should ever do.
Right.
I just had lost track of time, and I was like, oh my gosh, it's due today. I thought I had the next day. It's pretty bad when you run up against the clock like that. But it got reversed and remanded back to the same trial court, which we had wished.
That was my question.
We didn't want to go back to the same trial court with
Right.
the same judge and the same people.
Same
but
bias.
But ultimately, a couple of different things can happen. You can ask for a recusal of the judge if it's that biased. You rarely are going to get that. It's really difficult.
And if you ask and don't get it, my fear
It's
is
sour grapes.
Yeah.
The rest of the whole system hates you because they think that you're just, it just doesn't work. You can also hope and pray that judge it gets removed from office or is, voted out, which has happened on a couple of our cases.
Yeah.
And but it may be that in what happened in our cases, we went back to court and we were just ready to fight it to the end because it wasn't judicially fair. It was just so unfair. It was worth fighting for. You shouldn't give up if justice isn't done. Mm-hmm. And the other side knew eventually they were going to lose, and they ended up settling with us. Mm-hmm. So what was that verse in the Bible that says, on your way to court?
Settle with your enemy on the way, lest when you're there, he turn you over to the judge, or no, the judge turn you over to the jailer and until you pay him full.
Yeah. You always remember that. How do you remember that?
I don't know. I just do.
That is the most true statement. Mm-hmm. And just going back to, just the Bible being the most important book ever. I mean, it really for attorneys too. When I always have to go back because they have the, Proverbs and
Psalms.
And wisdom. They have these.
That's Proverbs and Psalms, the book of prayers.
The Catholic Bible's got the other wisdom and the wisdom Bible.
It doesn't have Psalms in it?
It does. Okay. But the Catholic's they've got 7 extra books, and they're the ones I go to because they're like Reader's Digest. You just go to it, and it's like, oh, this is exactly what I need to read. Mm-hmm. So, but anyway, that's really important because people really should try to settle. As opposed, if they can,
then push it and push it and push it.
Just even as an attorney, doesn't it just sucks the life out of you?
Yeah.
Having to, because you, as an attorney, don't you feel the pain that your client feels?
Oh, yeah.
You want justice. That's why we are doing what we're doing. And, if you're a decent attorney, a person with a heart and a hardworking one, you're going to work as hard as you can. Now, then you've got some clients that just don't listen. It's like you don't have a case.
That's terrible.
Yeah. Anyway, so appeals. I stopped you blank.
No, I
short.
did the introduction. You've got something on deadlines on appeals, and I think it's important for our listeners to know that in appeals, deadlines are everything.
They are. They are the drop dead deadline.
So Toni, for example, when you were sitting in an airport on your way to Greece and you wrote this brief,
I had a laptop.
Was it the appellant's brief?
Yes.
What would have happened if you got that in the day you thought it was due the next day? Would they have just rejected it?
Well, no. The good thing is it's the notice of appeal that's the drop dead deadline. You can rarely get around that. Mm-hmm. But the brief, you can be a day late a lot of times.
Well, let's talk about that. So you can be a day late and the court won't ding you?
Well, no, you're really pushing it. I mean, don't rely on that by any stretch of the imagination. But the drop dead deadline for the appeal notice it's almost impossible to get around that. It's like, if you know you're going to appeal, why wait to the 30th day or the depending on what the deadline is, which we could get a little bit in on the deadlines right now. I mean, I'm doing this sort of off the top of my head, but what we were talking about earlier was in family court. And So many people have been in family court because you've got all these different
Sure.
people have kids,
Divorce,
people
custody,
it's the
parentage.
age old, the 7 deadly sins. Maybe your marriage isn't working. Maybe you're tempted. Maybe we always do the Saint Michael prayer because there's some evil demons out there floating around that are some tempting beautiful girl is out there, or you've got a mean husband or a mean wife and they want to kill you.
Yeah.
So you're in family court, and but you have a lot of child issues in family court. The parents may not be getting along, but the children are caught in the sway, and what happens is that's the court of original jurisdiction. As long as those kids are living in that county, you're going to be in that same court, just like in probate court, for the length until the kids are 18 or 21 if they're disabled or older or whatever. And so you're going to be back in front of that same judge, or at least in that same court, who's going to know the next judge forevermore. And so a really important thing to know is that if you're before the associate judge in family court, and this is in the Texas Family Code, if you get a bad ruling before the associate judge, you have 3 days to appeal it. You're appealing, and it's not called an appeal, but if you look in the family code, I forgot what the name of it was, you're asking for a rehearing in front of the presiding judge. If you get that in there, and you can actually do it that day orally, you can say if right after the rendering,
ruling.
before the associate judge, you don't have a jury because it's usually temporary orders, or you're asking for a reconsideration, or you're asking for something in the case that's already been heard or already been agreed to by some settlement. If you've got the associate judge before you, and these are just elected officials, and the associate judge is not elected, they're just appointed by the judge. And the ones that are in Harris County right now, they're new. The Democrats were elected, and this court was very good, the court that I was recently in, and very professional. But the judge was only licensed in 2004. The associate judge was only licensed in 2009. Neither one of them had any practice that I could see before with a big law firm, and they both went to Texas Southern University. So this is not like with Will Hyde or some of the bigger firms that have been doing it forever. These are judges that don't have the same experience or the skill set, at least not the longevity of having heard everything.
Wow.
So if you get an associate judge and you get a bad ruling, all is not over. They may not know, and you may need to go argue better law. And if you ask within 3 days of that ruling, you can bring it forth again in front of the presiding judge.
The presiding judge. Okay, well, listen, we're going to take a quick break, and we're talking about appeals. When we come back, we're going to continue our discussion on appeals and the process. We'll be right back.
Hispanic Chamber Connections with Dr. Carlos Sanchez, President of the Woodlands Conroe Hispanic Chamber of Commerce, featuring event announcements, member highlights, and more. Tuesdays at 1 p.m., broadcasting from the heart of Conroe, Texas on irlonestar.com and Conroe's FM 104.5, 106.1.
Does volunteering at a nonprofit horse sanctuary sound wonderful? Or are you a veteran or a veteran spouse and think trying a peer group session through a local Horses and Heroes equine program might be worth trying? Henry's Home Horse and Human Sanctuary, located in Grand Central Park by appointment only, is home to a growing number of rescued and donated horses. Visit our website at henryshomehorsesanctuary.org or check out our Facebook at Henry's Home Horse and Human Sanctuary for more information.
A Lone Star Community Radio is ready for the summer. If you or anyone you know is looking for summer internship opportunities, a Lone Star Community Radio is a great place to grab the mic and be on the air. A Lone Star Community Radio offers a great opportunity to those interested in learning about the radio world all year round. Be an on-air personality, talk show producer, or YouTube, TV, podcast editor. Contact the station at info@irlonestar.com or call the station's message line at 936-647-3776.
Path to the Plate is a research-based education program that helps consumers understand how their food choices impact their health by making the connection to agriculture. Learning about how food is grown and produced, and how consumers can make better food choices for themselves and their families, Path to the Plate is all about dispelling myths and misconceptions. Find out more online at pathtotheplate.tamu.edu. We are Texas A&M AgriLife Extension, helping Texans make their lives better.
Hey guys, this is Connor.
This is Dick.
This is Chris.
And we're with the Ticket Stub Podcast every Thursday live at noon on 104.5 and 106.1 FM in the Conroe area. Also, anytime at irlonestar.com. You go to irlonestar.com/TTS. You can find all of our social media.
And don't forget, we give away 2 tickets to the Grand Theater on every show.
If you like movies and you like complaining or celebrating anything that has to do with the silver screen, check out the Ticket Stub Podcast and join us every Thursday at noon o'clock on Lone Star Community Radio.
A Lone Star Community Radio is looking for those who are interested in hosting their own talk show with monthly and weekly slots available on Conroe's FM 104.5, 106.1, and on irlonestar.com. Start your own podcast, create your first YouTube channel, and be on TV. Contact Lone Star Community Radio online at irlonestar.com or call the station message line at 936-647-3776 to take your first step into the radio world.
Listen in Mondays at noon to hear Conroe news from local nonprofits, businesses, upcoming events, Conroe Park events, news stories, and information that matters to you with your host, Margie Taylor of Taylorized PR. For more information about being a guest, visit irlonestar.com/Conroe Culture.
Lone Star Community Radio is ready for the summer. If you or anyone you know is looking for a summer internship, Lone Star Community Radio is a great place to learn the radio and TV business. Contact the station at info@irlonestar.com or call the station's message line at 936-647-3776. Lone Star Community Radio offers a great opportunity to those interested in learning about the radio world.
Welcome back to the Legal Connection with Toni and Cheryl. Toni and I are here today talking about appeals, and we're talking about the procedure. Toni, before we start talking about the actual what happens in the appellate court, I think our listeners may want to know, we don't want to get too technical, but that after you get a final judgment in the trial court, you have 30 days to file your notice of appeal. We were talking before we went to the break.
In district court, it's different. In JP court, I think it's 10 days.
Yeah, okay, so JP court, we got 10 days. Family court, we have
30.
30.
Well, it's 3 days if it's from the associate judge, and it's 30 days to file a notice of appeal, but you don't. But a lot of times you don't want to file just a notice of appeal, which is just a little one-sentence thing.
That's what I'm getting to.
Okay.
You can file an extending motion.
Yes.
Right, because that's what you're about to say, I'm sure.
Yes.
But first I want our listeners to get it clear in their minds, so you got 30 days.
Yes.
Now, if your attorney, if you decide, if you're not represented in one of these one of these courts, you need to get an attorney if you get some judgment that you don't like, because an attorney will have 30 days to file an extending motion.
Right.
Which will give you 90
But you can do
days.
it too as a pro se. It's just more difficult.
Yeah, that's true.
Yeah, I mean, and to go there, just briefly, there's all kinds of extending motions, and you can look this up if you just Google extending motions for appeal or whatever. But I had a recent case that we lost on a bench trial, and we couldn't believe it. It was like a slam dunk. It's like, how did we lose this? And so it was a case that I had done for a really low rate, and I was like, I'm just going to file the notice of appeal. I'm not going to do an extending motion. I'm not going to waste my time because I thought the judge is just wrong. And we ended up filing what was called because it was a bench trial, you have to request, I don't think you have to, but it's in fact, I really should just
A rehearing?
talk about,
A
no, it was
motion for
findings of
reconsideration?
fact and conclusions of law. In fact, let me just say what those are real quick.
right.
You have to request, if you have a bench trial, it's different from a jury trial. And because you don't know what the judge is thinking, you can go talk to the jury afterwards if they'll talk to you. A lot of times they don't want to because they didn't like you or they're busy or whatever reason. But most of the time, a jury, at least a few members of the jury panel stand back and say, this is what we liked about the case, this is what we didn't like about the case. And it's usually only not usually, it's going to be with the attorneys. They're usually not going to talk to the parties. But if it's a bench trial, you really don't know a lot of times because the judge doesn't have to tell you why. And so you have to request you have to prepare something called a request for findings of fact and conclusions of law, and it's actual something that you can look up if you Google it. You can see the format. The Texas Rules of Civil Procedure provide that the deadline to file a request for findings of fact and conclusions of law is 20 days after the trial court signs its judgment. So it's not when the ruling was made. Even I don't like to really risk that. I usually like to do it before that. Your deadline is 20 days after the judgment, and that's Texas Rules of Civil Procedure 296. But if you Google it, you'll see that number. The deadline for the trial court judge to file findings and fact and conclusions of law is 20 days after the party requests them, and that's the very next rule. It's 297. The truth of the matter is the findings of fact and conclusions of law are prepared by the attorneys. They're rarely prepared by the court. So what you want to do before you go into it, so the judge knows what she's looking at, is each attorney will file their proposed findings of fact and conclusions of law, because the judge is busy. They're not really looking at this all the time. If you get a really good judge, they're reading everything. But for the most part, they've got so many cases that are running through the court. Yours just another number. So you want to prepare them for that. Really sell your case, right? Now, if the trial judge misses this deadline, which is not uncommon, because a lot of times the attorneys don't turn those in, the requesting party must file a notice of past due findings of fact and conclusion law. It's just a notice saying, hey, court, you didn't give them to me.
And what is that, 10 days after they're due, 20
The
days?
deadline for doing this is 30 days after filing the original request. So it extends it like 50 days now, right?
Okay, so you file the original request.
Within
the
20
judge
days of
has-
the actual signed judgment.
Within 20 days of the judgment, the judge has 20 days from when you file the request to respond.
Right, and if they don't, and you've got to mark this on your calendar, 20 days from the date that you filed it, from the date of the judgment, because they're not keeping up with it. You are. The onus is on you as the attorney or the pro se party to get this filed, all right? Now, after the judge files the finding of fact and conclusions, a party may want to file a request for additional or amended findings or conclusions. The deadline for doing this is 10 days after the judge files the original. So in other words, the judge may have gotten it wrong. So it's almost like a little mini reconsideration of what the judge said.
Right.
And judges will get this wrong too, because what if the law has changed on your issue and it just came out? Then you want to follow this now, because you don't want to waste your time in the appellate court, save yourself some money. So you're always kind of keeping up with all this stuff. Now, per the Texas Rules of Civil Procedure, when an appeal from an interlocutory order is permitted, the trial court is not required to follow these. Now, what is an interlocutory order? It's an order that's not final. In other words, a temporary, in a divorce, a lot of times, and I would say 75% of the time, I'm just using a number, when a party files for divorce and it's not amicable, you need to file a motion for, first, a temporary restraining order to stop everything once they're served, because what happens is the other party, not necessarily the bad one, but the other one's mad now, they'll go into bank accounts and wipe all the money out, or they'll start selling things, or they'll move assets. And without that temporary restraining order, you're married or in a partnership for a business, they can do this, and it's perfectly legal to do that. But they're mad. And so you need that TRO so that when they get it, they don't get, like people do when they get mad about something, they don't do something crazy like wipe you out. And so then after the TRO, you've got 14 days to, usually it's 14 days that's in place, that until the court will give you a hearing date, and that's served upon them. So the TRO is before the service. Then you get a date when it's filed from the judge for when you can have your hearing, and that's your temporary injunction hearing. These are after that particular hearing is held, which determines the temporary child support. And these temporary orders can go on for 18 years. Sometimes you think they're temporary, but they can be forever if you don't finalize them. And it's horrible, because you're always in a state of sort of flux. And so another reason to try to mediate, because the party that's got the money will starve you out while you have these things going on. And then who is injured by it? If you have kids, it's the kids. If you have a business, it's the business, and maybe you too. And so what happens is you get that particular order after this hearing, and usually it's like a full-blown trial.
Yeah, the temporary injunction hearing.
If you win that, you can actually win your trial, because a lot of people are like, okay, I can see I'm going to lose this thing or whatever. So don't take temporary injunction hearings lightly. They're very, very important, and you need an attorney if you don't know what you're doing. Don't just think I'm going to show up for court and do this. If you've got something you're really disputing about the kids or the property, and I'm talking family, could it be any type of civil case, then you really want to make sure you're prepared for that with the admissible evidence, with your teachers or medical records that are in admissible form, that whole thing. Now, the order that you get from that is an interlocutory order, because it's not the final order. any order that is not final can't be appealed. But if it's a bad order, like the judge has made a ruling, like we were talking in a recent mediation I did, the Texas Citizens Participation Act is all over the board right now. I mean, it's like they're just now kind of getting down to what it should be. It should be a really good law, but it's been ruled on improperly so many times that it's a bad law.
Right.
And so the courts are trying to iron out all the issues with, like you can't just defame a doctor or an attorney by writing somebody a bad letter about them because that's not a public interest. But rulings are going the wrong way.
I know.
Because people are getting away with this.
Too broad,
and they shouldn't
too
be.
broadly applied.
A homeowners association that doesn't let you go talk to your neighbors and then files a bar grievance against you or prohibits you by saying that the signatures that you got aren't valid. That's a violation of the Texas Citizens Participation Act. And the winner of that case, win or lose, if what that is brought, the prevailing party will get their attorney's fees, which is a big deal if you've got an attorney that's charging you, $800 an hour. So that would be, though,
An interlocutory
those are
ruling.
You can mandamus those, and a mandamus is I can't appeal this because I don't have final judgment. But this really was so bad, and I am so injured by it. I have no other ability to be compensated for this because the injury will be that severe, like all your trees are being taken down, they can't grow back again, or you won't have your child for the next 2 years while it's in court, and it's a critical time because they're training for the Olympics or whatever the case may be. So you want to mandamus that, and that's when you go directly to the court. It's a really fast appeal. They're like appeals, but they're fast moving. And don't be afraid of them. They're kind of expensive, but if there's not justice, you need to go forward with that.
Why do you say they're expensive? What do you mean?
Well, because you're
much?
not just in the trial court anymore. You're actually saying, you're insulting the judge that you're now saying, Judge, you made the wrong ruling. And so that could backfire on you. So you want to think twice about mandamus in a judge that, particularly in a family court or court where you're going to be before this judge a lot, they may be nice and have a heart, but I think human nature is that person mandamus me. I'm going to look twice at them next time they come up before me.
Right.
Particularly if you're not paying campaign contributions toward them, and you're not the party that's got the money. And I'm not going to say this to any one particular court, but the truth of the matter is, going all the way back to ancient times, you follow the money. If somebody is giving campaign contributions to whoever it may be, and they're giving a lot more than your opponent is because they've got control of the money, which is really sad, but a lot of times it is the male in a marriage, or it may be the partner that has control over the finances, or the bookkeeper that's not being watched closely.
Right.
That person may be also giving campaign contributions that may not be showing up when you look at them when you go to the state records, because they're under like a fund, or it's through somebody else. And a lot of times it's who you know. So everything is very political. You have to kind of watch what you're doing. Justice can be done, but you have to make decisions that are wise based on your facts.
Yeah,
right. And appeals that's very, very important for appeals. But all that, just wash all that away with the bathwater. And the truth of the matter is, justice can be had even if you have no money. If you fight long and hard enough, justice can be had. You just can't give up, and you have to know your law. You can't assume that you've done this before and you can do it again. You have to have a skill set for it, or ask a lot of questions. What I have learned, that if you want to look for, if you're doing it on your own, or you want to check up on your attorney, is you want to find a case that is similar to yours, and you want to look at the actual pleadings. You want to look at what was done in the court records, which you could do by Googling the court records. Any citizen, anybody can get access to the public record. Watch what was filed. If it isn't, if they haven't made it so that it's censored because it's got personal information in it. This goes for any court, whether it's probate court, federal court, family court, not JP court, but they're a little bit harder to find because a lot of the JP courts don't have all the records online. Traffic tickets, forget it. If you think you got a bad deal on a traffic ticket, that's just ridiculous. Just pay your ticket and move on. I mean, those are really ridiculous things to fight. They're just Class C misdemeanors. But if you're dealing with a lot of money higher up, there's a lot of corruption. It may be that there's not corruption. It's just it's who these people know. It's just that they're having dinner with them or something, and it's just they may not be getting all the facts because they haven't read everything. So you just have to kind of fight, and that's why we're doing the show on appeals.
Right, and so you can mandamus a judgment, and then you proceed through, and that's at the
A
appellate
mandamus
level.
is going to kick it back to the court to make the
Right.
mandamus is either going to tell the court, we're telling you what to do, or you're going to be, sanctioned basically by the higher court.
Right.
So we're going to reverse and either render or remand back to the trial court, but during the trial to correct it.
Right.
An appeal will do something very similar after a final judgment. It can reverse or remand it back to the trial. It's just generally a longer period.
What is the percentage of cases that are overturned on appeal?
Gosh, I don't know. I guess it would look at the court.
I've heard it's like 2%.
Then you know what? I say never give up, because I had a track record that was like 100%, where all of my cases that I went up on appeal were reversed. And that doesn't mean I'm particularly smart. It just means that I knew that it was wrong. I mean, it's like if you get a ruling and it's not like, man, I wish I could have won that, I'm mad about it. It's not emotional, but it's like, that was flat out wrong. I mean, this law and these facts compared to this case, this was ruled wrong, and then you can appeal it all the way up to the United States Supreme Court. And I have one right now that, in fact, I have two cases that if I don't get, if I don't get a just ruling in the lower level appellate courts or even the Texas Supreme Court, these are really good cases on certiorari because there's cases like them that have been won with almost the exact same facts. And then that kind of goes to the next thing. What we were talking about was, just briefly, the kind of post-judgment pleadings that you file to extend a case. So you don't just have to file the 30-day notice of appeal.
Right.
Because once you file that and you get the clerk's record, you request that. You've done that before. And these days it's so I guess digital. Everything is not like it was back even 10 years ago, that everything is, you don't go to the court anymore and get the record. You actually go to you go online, and you have to have, you have to be in that court. Even if you're pro se, you have to have like an admission to be able to work with them. And then you can get access to the clerk's record and access to the reporter's record, which was what the court reporter actually transcribes. You have to pay the court reporter for that, and then you file your brief. The problem with filing a notice of appeal is, depending on what your schedule is, that's going to happen really fast once you get the reporter's record and the clerk's record in. And I have done so many cases, appeals for summary judgments, because as we've talked about before, summary judgment can give you a really bad rap really quick. It is not the Constitution that you get ruled against on a summary judgment. The Constitution says you'll have a trial by your peers,
of your peers.
Not one judge that's going to decide, maybe biased.
Or on a procedural issue.
Right. And summary judgments are done specifically from the record. There's nothing oral about it. You have to have everything filed within 7 days of the hearing date that's set. And there's a lot of procedure for summary judgments, and so many cases are ruled against on summary judgments that are completely improper. And on a summary judgment, you don't have to ask for the reporter's record, because it's not a ruling that takes in any oral testimony as evidence. It's all in the record. But they also had a Texas Supreme Court case that came out a few years ago that the record doesn't have to be everything that you've submitted in the actual summary judgment evidence. It can be whatever's in the clerk record at the time. That's new. That wasn't that way when I was in law school. I mean, I would have made an F on my final if I had tried to say that. So you have to kind of keep up with what's going on with the law.
Yeah, absolutely. Okay, well, listen, we're going to wrap up. Thanks for listening. Toni Lynn Collins and Cheryl Ellsworth Jahani have been here talking about appeals, and maybe next week we'll just continue the discussion on appeals. We want to remind you to
serve God by serving others.
And have a great week, guys.